Okay, get a hand to go to the Coteca.
Madam.
Allow the meeting to take a minute or
Can allow a space kindly for the cameras?
Excuse me. Mama, kidogo mama. Kidogo mama.
Guys, songa.
Ya, usungini sembona. Ini lebih kan? Lebih.
Per persoon. De allerbeste last minutes boek je nu tijdelijk extra voordelig. Nu op toei.nl. Toei. Live happy.
I have it, but I don't know if I have it.
No, like nahamia huko jina bagi yangu sawa. Bagi yangu mtanisama.
Sikuja hapa, kuja simamia. Sekonde. Mimi hizi pia sasa. Sawa. Ndio watulie.
Thank you. Pia utaona binguni.
Ndaona. Tuko tu wawili. Lazima mimi nakula pia. Lazima alete abebe Bible na Quran.
Decided to overcome problems SPC route and have decided to assist
hearing for the petitioner alongside Maura Kabata, Vice President of the Law Society. That is the first petitioner. Jose Mano, Council Member. Jose has stepped out, but he is within. John Kopere, Council Member. Willie Otieno. Evans Ogada.
Present, Your Lordship.
Moses Mutungi.
Present, my lord.
Is the counsel on record from VR advocates?
Utungi.
Wangare Kagai. My eyes are deceiving me. Director. Here. Let us say. Present. Abna Mango.
Present election.
Babu Owino, the Honorable Babu Owino, I should give him his full title.
Present, my lord.
Nordin Kagai.
Present, my lord.
Pius Oyo.
Present, my lord.
Joki Sara.
Present, my lord.
Mugani Boro.
Present, my lord.
Vincent Kisukwa.
Present, my lord.
Brian Mushiri.
Present, my lord.
Ochieng William.
I'm present, your lordship.
And for the respondents, I can see he has a team now. So I will ask you to introduce yourself.
Good morning, Lord. My name is Emmanuel Victor. I am here together with Mr. Christopher Marvel and Millicent Gerard for all the rest of them.
Je beveiligt je huis met een camera, maar wat als je de notificatie mist? Daar maakt VerySure het verschil. Ons alarm staat 24/7 in verbinding met onze meldkamer. En bij een inbraakpoging komen onze professionals direct in actie. Beveilig je huis vandaag. Nu met gratis plaatsing van een videodeurbel. Ga naar verysure.nl.
Maybe before Mr. Peter Mungai says anything, I should say that we were actually ready and eager to proceed, and especially on the issue of colleague Mr. Peter Mungai.
My lord, just for the record, Mr. Mungai appearing with Buta, who is on the way. He is down there. Mr. Wahome
I'm present, my lord.
for the family.
The Lordship, for my senior Mr. Peter, you see, there is the preliminary issue of compliance. There is the senior counsel. Well, that is why we are in court. It was for the issue of compliance. My Lord, we have the director of criminal investigations who has done summons by the Honorable Court. All these what we have consistent all these things. Well, before you address it, you don't file Mr. Maro will need to pause and allow Pardon my what? Well, we file past one to 14 weeks. We are responding to file them without me. Well within the provisions of the law. You filed
Addition.
Yes, Father.
Your Lordship, if I may. My name is Marvel. I'm on record, so we are on record for all the rest of that. When we appeared before you, Mr. Marvel, you were still given a floor.
Yes, my lord.
So that we complete.
Yes, I'll figure out from where I like. My lord, I was saying we filed sworn on, we were sworn on the 2nd day of July. Past sworn by Sergeant Patrick Bwire. Patrick Bwire. Yes. My Lord, the third affidavit, that is the father affidavit, was by Leonard Sierra, sworn on the 2nd day of July 2025. They respond both to the motion and to the petition, and they are filed within the provisions of the Mtumba Case. That gives us 14 days to respond. My Lord, we have in court. First one to yes. He has already introduced the affidavit. Yes. My Lord, before further proceedings, we take I wish to indicate that this morning, sworn by William Wajiko Getonga, Mr. Ndiangui Kinyagia, sworn by he's an advocate of the High Court of Kenya, and he's a cousin to Ndiangui Kinyagia, the subject matter of the habeas corpus. We have availed a physical copy in addition to the one that we have uploaded, and basically this affidavit it has been served. This affidavit is indicating that yesterday at night, in the evening, late evening, the deponent, Lillian, was informed by Ndiangui Kinyagia that he was well and safe and was calling from an undisclosed location. I had had.
So the second petitioner informed the deponent that
he was safe and but in an undisclosed location. Yes. The second petitioner and Mr. Wahome Dhuku called me at about 9 p.m. yesterday.
The second petition?
No, the mother.
The mother
and yes, and Dhuku. And I had a meeting earlier with the mother at around 5 p.m. in my office.
So the mother to the second petition?
Yes, and Wahome Dhuku called me and not Wahome Dhuku is my co-advocate.
Yes, call him your learned friend.
My learned friend is Wahome. Sorry, my lord, sorry. And my learned colleague is Wahome Dhuku.
He sounds like he's a stranger in this position.
Sorry, my lord. Yes. And
so they called you?
They called me, yes, 9 p.m. yesterday.
Last evening?
Last evening. And I informed them that if given the, they informed me, my lord, to inform me about the telephone conversation between Lilian Wajiko and Ndiangui Kinyagia. My lord, since the mother had instructed me to come and appear for the family, I informed my married colleague, Mr. Wahome Dugu, that it will be important the person who had communicated with Ndiangui Kinyagia to swear an affidavit which I will file on behalf of the family.
So that's why you had to file the affidavit? That's
why we had to file the affidavit. Because I've not talked with Ken Ndiangui myself.
Yes.
My father.
Let's remain there.
Yes. Yes, my lord. So I also informed them that because this was a matter that was going to appear before you this morning, that they ought to get in touch then to Mr. Ndiangui Kinyagia and inform him that it would be prudent, that was on my advice, that he should be able to come and appear before you this morning.
So you asked me?
Yes, I asked them to ensure that he is present for these proceedings today. At about 10:40, today, Mr. Lale colleague, Mr. Zuku and Lilian walked into this court, accompanied by Ndiangui Kinyagia. I have had a brief conversation with Mr. Kinyagia.
You have seen him?
I've seen him.
And had a conversation?
A short conversation with him. He appears very traumatized and sounds as such.
He appears?
Very traumatized. He both looks it and sounds it. And therefore, because you are in court and the cameras were all over photographing us, I have not had a session to be briefing on the relevant matters that are the subject of these proceedings. Therefore, apart from him confirming his very big fear for his life,
So he expressed?
He expressed, yes. I would like, and I request this honorable court to grant the family and myself, we have all met in court when I was meeting him, to grant time for us to be able to talk to him in confidence and in privacy. And since he still appears to be very traumatized, we urge that any time in the course of next week, he will be given an opportunity to come back to this court, accompanied by him, so that he is able, and ourselves we are able, to be of further assistance to the court. I regret the fact that I cannot be of further assistance at this stage until we have had a proper session with Ndiangui Kinyagia to know exactly what was happening during those traumatizing 10 or so days. So that's all, my Lord. My Lord, Mr. Ndiangui, please stand up. That is Mr. Ndiangui.
Lord, as he makes the vehicle, just for clarification, on what my learned senior was talking about, the affidavit indicates that the department was contacted on Tuesday, not yesterday, so for correction of the record.
Yes, I've seen what you said. They want me to record you.
Yes, Your Lord. In any case, it's clear on the basis of the affidavit itself.
Yeah, that's what I'm saying. I've seen it. So what were you saying?
I was just pointing out that correction.
Second petitioner. Contacted William.
On Tuesday evening.
Tuesday was first.
Yes. Yes. On 1st of July. It's correct.
You are just not yet. I can take this. So who else wanted to say something? The petitioner is coming.
We are happy and relieved that the case of petitioner is in court and appears well. But there are procedural issues of compliance, which I believe we can proceed with still now that the DCI is here. There are issues about the modus operandi because these cases are becoming so many. And directions of this court, after listening to the answers the DCI may give, may help save the court the time we have spent. So we are seeking your indulgence, but now that the DCI is here, we at least can deal with matters of compliance today. And any other procedural issue with clarification from the court and for the safety and well-being of everyone. We'll be happy to proceed with the DCI.
Senior Counsel, I look at my direction. I want us to look at it. They were very clear.
I have a copy.
Yes, they were very clear on what I wanted. This was we are here only for one subject.
I'll read number 5.
I'm aware. I'm aware. I'm looking at the subsequent directions. But I should grab why I need them. Why I need them.
Okay, yes, I'm seeing now number 5.
So can we Mr. Kibe.
Yes, but I cannot say.
Because you've made us participate. And we want to participate.
Yes, we are. Yes, but the petitioners can speak for themselves.
I agree.
Yes.
I have the petitioner, second petitioner in court.
Yes, the second petitioner is in court.
I wanted him dead or alive.
Yes, that is.
I have him alive.
Yes.
Once I have him alive, you have requested me time with him.
Yes,
and it's important.
Yes.
So, senior counsel, I think I'm not deciding, but I think the fairest thing to do is to allow the family and you lawyers have a conversation with the second petitioner, and then after you have that conversation, then we will decide how to proceed next. My intention this morning was to have him, and I have him. I present him to the Kenyans, that he's here, he's alive. So any other thing is now after you could take a fresh instruction. Am I right?
We are most obliged. It's just that we thought we could take advantage of the presence of the DCI, because apart from that, there were compliance issues. Let me just finish. There were compliance issues which we raised on
we are not doing the petition. I still have the petition to dispose of.
Okay, then with that I will see.
We have the preliminary stage. We were looking for him. We have him.
And we are relieved.
So can we still have a petition to deal with, Mr.
Yes, ma'am.
But
in fact, my lord, we still have a petition to deal with. And in the meantime on that application, we are relieved that the second petitioner applicant has been found. From our position today, we had come to dine, and our food is here. And subject to I am saying, my lord, we had come to dance. Since our work as lawyers and our witnesses in court, we may miss this opportunity. It is a golden opportunity. I am reading this in line with what was found in, by your brother Justice Mugambi in petition E436 of 2024 and your brother Mwamuye in E0714-2024, that orders of the court are not pious orders. They have to be complied with. Now that the director of criminal investigations is here, there may be questions that we may need to ask to prepare ourselves in the debrief that we will come to explain to court. He may elect, as you have seen before, my lord, on the day when, and his brother, Mr. Masengeli is here, on the day when the court wants to exercise its prerogative power, the petitioners are usually found. It is a modus operandi. Every time when they are almost getting to the corner in court, the petitioners are found. Now, since the director is here, my lord, we intend.
No, I will do direction.
Yes, ma'am.
You are making requests.
Yes,
I will do direction. But I want first to take into account the interest of the family.
Yes.
It's paramount to me.
Absolutely.
They want both the second petition. We still can ask him to come. And if you want to ask him questions, I'm here, he's here.
And your directions, my lord, are very well known.
No. If you want, he's here.
Yes, my lord, just if I may be
so let's have it in order. That we have the DCI, we have the petition. Right? The person I wanted. You want to ask him questions? He's here. Not as you know. I wanted to agree how we proceed. Can the family have first opportunity to talk to him? There may be something.
I'm actually drawing from your wisdom, my lord, that in this particular instance, as we learned last time, the primary concern was the life and liberty of the petitioner, second petition, and we are glad that he's here. He's alive, he's breathing. At this point also, Mr. Amin has acted complying with the orders, he's here. And from the petitioner side, we were ready to cross-examine him. But the family has made a request, which is also reasonable. You have a traumatized citizen who, for all intents and purposes, may be in a daze not even fully understanding what we are saying or going through. The request to be brief, give him time to compose himself, to understand the circumstances under which it could be traced. Then we reconvene. Once the second petitioner has debriefed with counsel, probably gotten medical attention, and is ready now to participate in the petition, all parties come back here. And my lord, the only point you are stressing, which now I'm guided again by your counsel, is the presence of Mr. Amin. We may need him. My vice president, I as deputy designate, the vice, would have wished it happens today, but in the circumstances, it may not be possible.
Oh, he's here.
No, I'm talking of,
And we are here.
and I was going to say, my lord, I was actually coming to that. And also recognizing that he's in charge of criminal investigation in the entire country. And getting him is sometimes difficult. And now that he's here, at least to the extent of the first petition as cancelled, we can take our bite at the chin when it is still fresh and here. And we question him, we preserve that we don't fall of instances where when we seek him to come to court, he says he has gone for an operation in Paraguay. Which may be a genuine operation or not genuine, as sometimes happen. So having blocked his diary for today, no prejudice will be suffered if we proceed with it today. But if the court is minded to consider the family request, we will equally be guided. And also, my lord, of import in this particular instance that we don't lose focus on, in the replying affidavit signed by the respondents in paragraph 20, the question...
I have
the affidavit sworn on 30th of June 2025 by Samuel Ite. Paragraph 20. There's a live issue which I would not wish that we gloss over. If the second petitioner were to leave court today, there is a real danger that he may be arrested or detained by the respondents. On this behalf and in the interest of justice, I pray that when the court is making directions as regards to the second petitioner, the court consider issuing an order restraining his arrest. If any arrest ends up in court, and he can be bonded to attend to this court when required,
so that the question that should be of our primary concern at this point is him getting medical attention and social support.
In fact, Mano will be happy if the director will just tell us that he will not arrest you. That we go probably just also for the court to feel the presence.
I confirm the application for some protection of the second petitioner this time. There is also one you are going to make, so I had to take it in giving this direction.
Yes, my lord, thank you. My lord, I've got an application to make. The first application I need to make, my lord, is in the report from the immigration to summon the deponent to swear an affidavit in support of the petition, one Florence Muturi, to attend court in the next hearing for us to cross-examine her. Because, my lord, there are certain facts that she point to that have led us to this. There are two affidavits. The first one was sworn on the first day of July 2025. 1st July 2025. And there is another one sworn on the 24th day of June this year.
So the data should begin the question.
The first one is on 24th day of June 2025. Yes, that's the first affidavit. The second one, my lord, was referred to on the first day of July 2025. Work in support of the petition and the motion. Secondly, my lord, in terms of the directions of the court, my lord, now that the DCI has come in answer to those summons, we pray that those directions will be discharged as regards the appearance of the DCI. And thirdly, my lord, the DCI, in light of what has been stated, would wish to be given an opportunity to speak on behalf of the directorate.
To have an opportunity
to address my lord on behalf of the directorate. Because they feel that they have not been keeping as regards this case, and they need to be heard. My lord, fourthly,
so I didn't get you.
Today, my lord, now that you've summoned me, wants to be heard because they have not been put there in this matter.
They say so.
Yes, they need an opportunity. I am not privy to the basis of our application. Walk about. Yes, and Mr. Petitioner. My Lord, I've addressed you first.
In behalf of the family, and I would want time really the second. That's number one. That's the primary application I have.
Yes.
And the other people.
My answer is simple. Mr. Kibe is not a party in this proceedings. He is not a party in this proceedings. With him letting the second petition in whatever capacity outside. If he was, I would be in a position. Yes,
so you're not able to respond.
My response is Mr. Kibe is not. Application made by Mr. Willis Otieno, my lord. And I believe, my lord, why
Yes.
there is a prayer that was sought for the unconditional release.
That's in the original motion.
It is in the notice of motion, my lord, the one that gives direction. It's prayer number 8. So, my lord, this is the prayer that has been sought. We have responded to this motion. And we are ready for it to be urged forward. And I believe it is only fair that we deal with this motion now before we consider any other oral application. I believe that you come for directions, my lord, so you can give directions on the hearing. So that
Canada in response.
Find out whether I got Mr.
because you called him. Come on,
Yes,
yes.
yes. I'm not saying I didn't.
family has a specific request. Petitioners, counsel for the petitioners. They are so that I give directions.
Yes, Minister.
Mr. Mugabe?
Talks about the Attorney General shall promote and defend the public interest. This is a habeas corpus application, the subject of the application. Family. And invariably. Instituted at the behest of the family. Sub-rule 4 of the Mutunga rule, sub-rule 4 of the Mutunga rules, the family of the second petition, of the second petition, of the second petition, to be added. Proceedings, my lord, and that is pursuant to Rule 5. Proceedings, my lord, and that is pursuant to Rule 5. Rule 5, this court has jurisdiction under those two rules. 5 and 10 to make such an order. Only 5 and 10 to make such an order. Attorney General to make such an order. Attorney General that you can have proper habeas corpus proceedings in which your lordships can lock out the family. So for purposes, so William, the family. So for purposes, so William as information will appear as an interested party, but information will appear as an interested party, but to the court, because all of us want to know where was he, and requested. But we can formalize the proceedings because we need to. But we can formalize the proceedings because we need to.
Individual have the need for him to be given an opportunity to get medical attention. Look elementary knowledge of myself. But we should decide by issuing the order that allows his liberty and opportunity to access.
I have the DCI report. I have the petitioner report. Second petition. I have parties to tell us. The other side wants to examine the DCI. So how should we give preference to?
I think
it is something we give the DCI here.
the family and parties. The application was about the well-being of the secretary. Even though we were rallying to go, we should hold our books.
We all don't like having to wait in long queues or for a long time just to get the service that you want, right?
same? No, my lord, yes, there. Second, that one is sworn on the 10th of July.
So you start on obedience.
Yes. So there's Leonard Fiele, then there's the first one. The third one is Patrick with. What 3 copies? Live, we have copies of it. Actually uploaded it. He's there, he can speak for himself. You personally.
No, you are now the leader.
Yes, no.
I told you are his senior.
Yeah.
Yes. Someone else who can assist you, maybe we are all.
Your Lordship, there is let's see have you seen the one that's
Yes, my lord, you are sorry. Can re-upload it so we don't.
Anything else?
Lord, I wanted to address your question on an issue that Mr. Gita has raised, but I see when Mr. Period, I see his important as better, but he is 38 years in the profession, and to me, that counts for something.
My Lord.
leaving what my vice president has said. I am the second senior most after senior counsel Karua. But I just wanted to bring something into context on the 4 applications made by Mr. Vita. The first one was on the summonings of the CEO of the Law Society. I appear for, together with the rest, the Law Society and the second petition. As to that application, the Law Society has no objection. In respect of the first application by Mr. Vita on the question of cross-examination, it can be dealt with at the appropriate time. What I am worried about are the second and third applications by Mr. Vita because they go against each other. The second application was to discharge the personal appearance of the DCI, but the third one is to give him an opportunity to address court, which is sort of supporting what my other learned colleagues had said about having a bite at the cherry today. So that the other parties were saying that he can be able to say something. He cannot just say it and go. He may have to ask some questions in relation to that before he's discharged. So while dealing with those 2 applications, you may have to consider how to balance the 2 of them in relation to having given him the opportunity and then thereafter discharging him and whether he will be cross-examined. Then as to the question of a formal application being filed by Mr. Kili, I think that has been addressed, and that was the forthcoming of Mr. Vita's application. So those are the 4 issues I wanted to bring to context for purposes of then when your Lordship is giving directions, then you can be able now to balance what Mr. Vita requires, what we also require, and the fact that at a later stage, since the other applicants are supporting the petition, they can be dealt with in the main petition, and the deponents, including whoever may be required, a notice can be given as is required by law that we will want to cross-examine you on these allegations or these depositions in your affidavit dated this particular day. That will be all.
Let me make it clear that the court is never addressed. It's the lawyers who address the court on specific items. So the DCI wants to speak, to take the witness box. He's here as a witness of the court. He's read what he wants to say, and then will be subject to cross-examination.
Thank you.
Those are the directions. If you are going that way, you clear the way for that. Bearing in mind, I have a specific request from the family. So if you want us to go that way, we take the stand, delayed for the reasons that the court directed you to hear, nothing more.
I think my learned senior, my learned counsel can be able to now.
So you look at the directions that issued, you will be here for a specific issue. We are not digressing any other issue. If we are sticking to that, that's what we are doing.
Yes, I want, let me address you on that because obviously there are some instructions. He says he wants to respect the issues of the family. Now that he has answered the summons request to appear, and the second petition is present, that you're discharging to start those summons have been paid. No, he's telling me to abandon the other application. So as regards this all is that tragic. Someone's actually
Mr. Peter, you have filed all you wanted to file in response to the petition.
To the petition, no. I was just dealing with this aspect. Because you know there are other parties. The accusations against other parties.
So you have not filed responses to the petition?
As regards the other parties. But as regards the IG, the DCI, both in their public and private capacities,
you have filed. And those are the primary parties?
Those are the primary parties.
So where my concern is there any other thing you want to file in form of a response?
I will file grounds of opposition on behalf of the other parties that are not primary. The Attorney General and the Cabinet Secretary. But today is Thursday. By Monday, I will file it.
You will file. I'm suggesting that we go directly to the petition.
That is okay.
You agree? Petitioners?
We are fine with that.
No, I can also file an appeal.
What's the response, Mr. Peter? Ask Mr. Maro if he comes to my court so often. He knows our responses to the petition.
I'm not been to your court longer than Mr. Maro.
I don't know when last year. But I'm sure you know.
Yes, ma'am.
So that's good. So I can give you 7 days?
Yes, my lord, that's okay.
Senior counsel, I restrict submissions to 10 pages. How many pages would you want to have?
I think 10.
10 will do.
Would do, yes.
What one with the petition because there are specific issues.
Then make it maybe 15, 15, yeah.
Mr. Peter, would you think you are
More than happy.
My lord, before you give your directions, perhaps you consider that the case be disposed by both submissions and reverbation evidence, because we still have that cross-examination.
Yeah, so does it make sense to file submissions before?
It does not.
Does it?
We should have it, have the cross-examination before submission. Submissions are a wrap-up. Yeah.
That's why I'm looking at change that. After I go on a date, you can have the hearing. It's not going to be hard to evaluate evidence. All the updates. We try to see what of the nature of this matter. Senior counsel, how long will you take to do your witness?
I think
we already have the affidavits. We you have the affidavit.
Yeah, but we are not even talking about witness. We are talking of cross-examining DCI and the deponent.
I'm talking of your case. How much time will you take to present your case?
I think our 1 day then.
1 day.
Yeah. Not more than 1 day. Yeah. It could even be less, but to be on the safe
Did
side.
I have affidavit already? They will come here that doctor affidavit and be cross-examined.
Although we have requested for somebody without any affidavit, the DCI, because it is his officers who swore, yet.
We will reach there.
Okay.
Let's deal with you. I'm looking for your side.
Yeah.
Don't worry, because they will come and we will cross-examine.
3 hours for highlights, but cross-examination would be a day plus. We had prepared that.
Are you suggesting that this will come without preparing?
No, but because of the menace of the problem we are talking about, we had come loaded more than usual.
Because of the threat that will take so long, I'm suggesting 17th and 18th of July to hear.
May I request we push another 2 days? I have a personal problem. I'll be out I'll be returning on 16th and 17th. I'm in Kampala. So if I could request from the 18th. And Kampala, I'm leave cancelled.
No, you said you are not available, so you... When are you in Kampala?
On the 17th.
Will you fly back?
It's a day trip.
No, will you fly back the same day?
Yeah, it's a day trip. That's what I'm saying. Going in the morning, back in the evening.
So we can take it in?
Yeah.
So we'll have to stagger it. We take 18, and then we proceed on 24. How is that? Mr. Binka?
18th and that's okay. I think it's confusing.
24.
18th and
That's okay.
some time allocation on that?
You will now come to that. Let's just have the...
A doctor from China showed the world how to slow down aging.
So, I suggest we start 10:30 each day. That's okay? the court issued specific orders and the DCI come to this court today and explain the whereabouts of the second petition of the DCI. Today, the second petitioner has been presented to court by the family, and the family has made a specific request to have time to speak to him and get to know what has transpired, and they also give instructions to the advocates. Mr. Binta, the respondents, and the DCI in particular, does not oppose his view. And since today was for explaining the whereabouts of the second petition, and now that the second petitioner is in the court, it's proper and appropriate that the family has time to listen to them and their advocates and take instructions and possibly have him treated. For that reason, we issue the following directions. This petition will be heard by oral evidence. Respondents have 7 days to file responses to the petition if they have not already done so. Once they serve, the petitioners will have 7 days to file a supplementary affidavit if need be. The families granted time to have the petitioner with them and taking hospital and medical attention. This matter will be heard on 17th and 24th of July. 18th, my lord. 18th, sorry, I had already 18th of July and 24th at 10:30 a.m. both days inclusive. In the meantime, the police shall not arrest the second petitioner, Ndiangui Kinyagia, since he is now a petitioner in this matter and they are required to testify. The second petitioner will be presented to the DCI officers to record a statement if need be, and it should be presented by his advocate, and he should not be arrested or detained until further orders of this court. Thank you. So we meet on that day, is comply with the direction.